January the 30th. The first thing I want to do today is just welcome a writing class from Washburn Law. I think they're 2L students. Professor Eunice Peters is here. She used to work in the State House, and now she's bringing her students over. So they're kind of in the back row back there. Thank you so much for being here. We hope you learn a lot and study hard. It's What'd you say? Stay in Kansas, exactly. Yes, we would love that. And we need you in Kansas, actually, when you graduate. So thank you. Welcome to committee. Okay, committee, are there any requests for committee-sponsored bill drafts that you would like to have introduced? Committee, anybody? Representative Vaughn.
Thank you, Madam Chair. I would like to request number 25 RS 0979, and this would provide an exception to the crime of unlawful possession of controlled substances for residents of Kansas who possess marijuana and are disabled veterans with a valid medical marijuana card issued by another state. And I'm introducing that on behalf of Representative Susan Ruiz.
Are there any questions? Objections? Okay, without objection, that request will be made. Okay, in the audience, do we have any bill requests for committee-sponsored bill drafts? Anybody? Come on up. Introduce yourself. Thank you. Is your mic on?
Thank you, Chairwoman Humphreys, members of the committee. I'm Jean Gowden, Director of Government Relations with Kansans for Life, and I would like to request that 25 RS 0980 be introduced, and the bill is about providing women with information about their right to seek compensation for injuries suffered due to chemical abortion pills.
Okay, any questions on that one? Objections? Okay, without objection, we'll make that request.
Thank you.
Okay, any other requests for bill introductions? Well, is there anyone online? Okay. And is Representative Carmichael online? Okay, all right, thank you. Just so I knew that he could ask questions if needed be, so, okay. Okay, thank you so much. Okay, committee, I will go ahead and open the hearing on House Bill 2131 and ask our reviser, Jason Thompson, for a bill brief.
Thank you, Madam Chair. Good afternoon. As you said, Jason Thompson, Reviser of Statutes Office. You have House Bill 2131 and my bill brief, hopefully. I won't go through it all, but I will give you the high points. The bill does require prosecutors to disclose their intent to introduce testimony from a jailhouse witness and to forward related information to the Kansas Bureau of Investigation. The provisions are known as the Pete Coons Memorial Act. The new section there on page 1 would go in the Code of Criminal Procedure. It would require a prosecuting attorney to disclose their intent to introduce testimony of a jailhouse witness regarding statements made by a suspect or defendant while such witness and suspect or defendant were both incarcerated. So that's the circumstances that we're talking about. The prosecuting attorney would be required to provide the defense with the criminal history of that witness, the witness's cooperation agreement, if there is any benefit that might result for them to give that testimony, the contents of statements allegedly given by the suspect or the defendant to that witness, and the contents of any statement given by the witness to law enforcement regarding all of those statements. The court can extend the time for prosecutors to comply with the provisions of this section if the information was not known or could not be discovered or obtained in time. If the court finds disclosing this information is likely to cause harm to the witness, bodily harm to the witness, the court can order that it only be viewed by defense counsel and not the defendant, and also can issue a protective order. Additionally, each prosecuting office has to maintain a central record with all the information necessary about cases in which testimony by jailhouse witnesses are introduced or intended to be introduced. The prosecuting attorney's offices then have to forward that information to the Kansas Bureau of Investigation, and the KBI will have a statewide database that is confidential and for prosecutors only, but will contain information about these jailhouse witnesses. The next piece is that if a jailhouse witness receives a benefit in connection with offering or providing testimony, the prosecuting attorney has a duty to notify any victim connected to the criminal prosecution. The definitions are there at the end of section 1 in subsection D. I won't read those to you. Benefit is defined, and jailhouse witness is defined kind of as I explained at the very beginning. It does not mean, however, a confidential informant, an accomplice, or a co-defendant. So those folks are not jailhouse witnesses. They're not subject to this section. And this would become effective on July 1st if adopted. And Madam Chair, as usual, I have the background on the prior bills related to this, if you would like that. I'll be happy to answer
Yes,
questions.
please. We were going to ask, so go ahead with that. Thank you. Well,
Representative,
I'm going to ask instead every time this time. So.
okay, good. Representative Carmichael's not here to ask, but I'm glad the chair is going to step in and ask for us. So we're getting used to this. So House Bill 2293 was the bill in 2024. The committee had a very lengthy hearing, a couple of different times it looks like, on this bill. Passed it out as amended. It passed the House 117-4. This was February of 23, I should say, February of 2023. 117-4 was the vote. It went to Judiciary on the Senate side, and it got out of committee, but it did not get above the line. There was even a motion to bring it above the line, which failed to reach the majority needed. It had a majority, but not enough to bring it above the line, the 2/3 that was required. So there's the procedural background of that bill. Then during conference committee on House Bill 2010 in the end of the 2023 session, House Bill 2293 found its way into a conference committee report. However, that report was not adopted by the Senate. And then the conference came back and they just decided to concur with the underlying House Bill 2010. So that eventually became law, but without 2293 being a part of it. So that's what I have.
Thank you. And you said that it was amended in 23. Was that was on the floor of the House?
The version
Or was
that
in
you have
committee?
in front of you reflects the version as amended by the House committee.
Okay.
I don't believe there
That's
were
what I-
floor amendments made. There were amendments made on the Senate side, and those are not reflected in this bill. This is the House passed bill.
Got it.
Yeah.
Okay, thank
This
you.
the same as the House passed bill.
Yep,
Yeah.
got it. Okay, committee, do you have any questions for the reviser? Anybody? Okay, thank you so much, Jason. Okay, first we'll hear the proponents, and I will ask Jean Phillips from the Midwest Innocence Project to come up and give us your testimony. If you'll just introduce yourself when you get up there, make sure the microphone's on.
Thank you, Madam Chairman. Members of the committee, my name is Jean Phillips. I'm a board member of the Midwest Innocence Project, and I litigate cases on behalf of MIP. I'm here today to speak with you on behalf of MIP. One of the biggest problems with jailhouse informants is reliability. There is incentive for those informants to not necessarily tell the truth in exchange for leniency for their own cases. They have an incentive to protect themselves and not necessarily to provide the truth. Since 1989, 223 people have been wrongfully convicted in cases that have jailhouse informants, and Pete Coons is one of those. He is the person for whom this bill is named. I'm not going to talk about Pete. You will hear from his kids later today about the devastating impact that jailhouse informants can have on individuals. And not only just the individual and the individual's family, but I want to remind the court that when we get the wrong person convicted, that means the person, or not remind the court, I'm sorry, the committee, that when we get the wrong person convicted, that means the person who actually committed the crime is still free. So I want to begin that although I am a defense attorney, I honestly believe that prosecutors want to use reliable evidence to convict. I don't think that there are prosecutors out there who are trying to hoodwink people. I don't think that their goal is to get a conviction at all costs. I think they really do try to do what's in the best interest. The problem is that there is the way that the law is set up, and I looked at what the Kansas Attorney General provided in their testimony. They are right that there is law, Kansas Supreme Court law and US Supreme Court law that provides when information has to be turned over, but that law is at the discretion of individuals. It's what we consider favorable, what the prosecutor considers favorable, when the prosecutor considers that there has actually been an agreement that requires that it be turned over pursuant to whether it's the disciplinary rules or the Supreme Court rules or the statutes. The purpose of this bill is to provide clarity. There is no discretion. There is no what do we determine as favorable or unfavorable. It very clearly sets out what you have to turn over and when you have to turn it over. Those are goals that we all should want. It provides for more reliable evidence and it prevents wrongful convictions. One of the confusions is over what constitutes a benefit and what constitutes when you have to turn information over. The problem happens because there is not necessarily a formal agreement between the confidential informant and the prosecutor at all times. And if it doesn't happen before trial, that information is not turned over, right? Again, what we're trying to do is to provide some clarity and to assist the prosecution. It very clearly sets out what has to be turned over and when. So while the while the state of Kansas, the Attorney General, is correct that there is actual requirements, there is currently significant litigation, and I've been involved in that litigation, over what constitutes a Brady violation, which is the US Supreme Court case that is referred to in their remarks. There's a lot of litigation over when a prosecutor has to turn something over, what constitutes favorable evidence. The point of this is to get rid of that discretion. The second point of this is it provides a way to track that information. If you have a person that is a jailhouse informant that is turning over information, it takes time and resources for a prosecutor to determine whether or not that information is reliable. And they don't have at their fingertips what happens in every single county that that individual person may be providing testimony in. One of the things that happened in Pete Coons's case is that the confidential informant was contacting people or prosecutors in various counties trying to provide testimony in various cases in order to protect his own interests and to decrease his sentence and to get some leniency. It is very difficult for a prosecutor in Johnson County to understand what's happening in Saline County or vice versa. The purpose of this database is to get rid of that and to provide all prosecutors that information. So rather than spending the time and resources investigating potential witnesses, trying to call around to find out about this person, trying to figure out who is reliable and who isn't reliable, that information is at the fingertips of the prosecutors. It is exempt from open records, so to the extent that there is concern about whether or not that informant would be, their lives could be in danger, or they could be hurt, or there could be some ramifications, which I understand is an issue. There is an exemption from open records so that that information is not going to be turned over. And the bill also makes clear that the information is available only to prosecutors. It's not available to defense attorneys. It's not like defense attorneys are going to get on the database and tell their clients, hey, don't talk to these 500 people throughout the state. It's not like there's going to be targets put on those people's backs. This is all going to be just for the prosecutor. The only time it has to be disclosed to the defense attorney is when the prosecutor decides to use that evidence. It doesn't have to be turned over to the defendant. It can be kept in the confidential control of the defense attorney, which is something that happens in lots of different contexts where defense attorneys who are members of the officers of the court are required to keep information confidential. There's a lot of things that we can't turn over to our clients. We can't provide birth dates and social security numbers and addresses for witnesses who are going to testify because it could potentially put those witnesses at issue or at danger, right? So we already have those systems in place, and we can do the same thing for these individuals who are testifying. We also have the ability to do protective orders, which will also protect these individuals. And to the extent that there is concern that these individuals are not going to come forward because they're very concerned about their safety, remember that when trial comes around, they take the stand. We know who they are when they testify. So to the extent that there's a safety issue, it's going to exist anyway. And so what we're asking is you just divulge that information to the defense attorney in advance so that person can figure out, that defense attorney can figure out how to address the evidence. I'm going to leave you with the idea that part of what makes our criminal justice function and function efficiently and make sure that we incarcerate the people who are actually guilty of the crimes is clarity. Law enforcement want clarity. Law enforcement want to know when they can stop a car, when they can search a car, when they can look in the trunk. They want some clarity. Prosecutors need clarity. They need to know what they have to turn over, when they have to turn it over. The last thing a prosecutor wants to do is to have to retry a case because they didn't properly turn over evidence. Retrying a case takes lots of time and resources. All the parties want clear rules, and the victims want clear rules. The witnesses want clear rules, and the public wants clear rules because that just provides for transparency. And when we have transparency, not just for the victims of these crimes, but for everybody who is involved and for the public, that only increases the legitimacy of our criminal justice system and helps our criminal justice system better function. Clarity is always better, and we encourage you to adopt Senate or House Bill 2131. I'm open for questions if you have any.
Thank you. I think we'll go ahead and hear from the next proponent, since you all are both with the Innocence Project. Ask questions of either of you then, and then.
Great.
Okay, that's great. Thank you so much. All right, Bay Scoggin, come on up and try to speak into the microphone if you can.
I think I also talk loud enough probably for it to pick me up. So thank you. Yes, Madam Chair, members of the committee, thank you so much for having me. My name is Bay Scoggin, and I am a state policy advocate for the Innocence Project. I will draw your attention that I have submitted written testimony which goes over all of the important facts that you need to know about the national landscape, including how many states have done this before and which ones. I will note that depending on how you count it, Kansas would be roughly the 14th state to put into statute these existing Brady obligations and create the state database. Other states like Texas and Nebraska are already ahead of the game, and so we are seeing lots of these bills come up across the country, including in neighboring Missouri. So I will encourage this committee to hustle if they want to get there first. A couple other notes just about the bill. This is ALEC model legislation. This is conservative endorsed legislation, and we have seen incredible bipartisan support, not only here in Kansas, but obviously across the nation as well. For those members of the committee that were here 2 years ago, the bill did pass out of this committee unanimously. It passed the House with more than 120 votes of support. Similarly, in the Senate committee, it was very well supported, not unanimously, but very close. A majority of Republicans and all the Democrats. So this bill really is supported across both sides of the aisle, and that's so exciting from our perspective to get to work on something that has so much agreement. The last thing I'll just get to add is to reiterate how Pete Coons' case is so instructive of this instance. As another example of how discretion of disclosure can be a challenge, in Pete's case, no benefit was ever actually delivered to the jailhouse informant. They were offered, there was a handshake agreement, but there was no written agreement, and there was no delivery of that inevitable benefit. So in that case, under the lack of clarity and under current Brady-Giglio, one could argue in a court of law that those probably should have been turned over, but they simply weren't. And it wasn't until we entered into post-conviction discovery that we were able to find the information about that deal and go ahead and use that as part of the case to exonerate Pete Coons. So I'm very grateful again for your work in this bill, and we will hope to support it. And along with Jean, I will stand for questions from the committee.
Okay, thank you. Committee, do we have questions for Ms. Phillips or Mr. Scoggin? Representative Barrett.
Thank you for coming to committee. Really appreciate it. And thank you, Madam Chair. I guess just two quick questions, if I'm able. On the first one, you're saying that it's not open to open records requests. I'm seeing here that there is a sunset on that, July 1st, 2029. So unless the legislator acts on it, if they accidentally skip it, miss it, my understanding is that list would then be available for open record. Is that correct?
Thank you, Representative Barrett. This is a very important question. The revisor noted that one amendment did get added to the Senate version of the bill, and that was to get rid of the sunset provision from that exclusion. We consider that a friendly amendment and would be happy to add it again.
Great. May I have one more? Thank you. And so then on my second question I have is just, so currently, so disclosure, I work in investigations for a prosecutor's office. So when I interview people that we're investigating, maybe providing information on other crimes that's going on, as part of Brady, everything has to be disclosed, and everything's in my narrative, everything's recorded. So I'm curious if, it sounds like this bill is trying to do something that's already in place. Can you, with the exception of the registry, is there any additional factors that you're trying to push that's not already included in statute? Thank you.
Thank you, Representative. Yes, we are trying to elucidate exactly what needs to be disclosed because of the issues that we see in current cases. If we thought the system was working and there was perfect usage of Brady Giglio in this state, we would say, great, there's no need to reiterate what these existing constitutional obligations are. Unfortunately, Pete's case is not the only case that we see this in. Nationwide, more than 220 different exonerations have taken place involving the use of an undisclosed jailhouse informant witness. So what we know is that these types of in-statute clarities help us prevent wrongful convictions, and they protect good convictions as well.
Thank you, Madam Chair.
Can I just add one comment to Representative Barrett's question?
Yes, go ahead.
So you're right that Brady information is required to be turned over. The problem is that Brady says favorable evidence. And so the question is, what constitutes favorable evidence to the defendant? And that's where the discretion comes in. And different prosecutors will come down differently on the issues of what constitutes favorable. So if there's not a formal agreement that's been offered and solidified before a trial, there are prosecutors who say that's not necessarily favorable because we don't have an agreement yet in place. That leads to a lot of litigation over what constitutes Brady violations. And I've been in those cases before, and we litigate all the time whether or not enough information was turned over in violation of Brady or whether or not there was sufficient evidence that actually even met the Brady. This clarifies that, and it takes the discretionary component out of it. So everybody, again, clarity helps make the difference in good, solid prosecutions, and that takes that issue away.
Okay, committee, are there other questions? I know this is a little technical. We actually do have a lot of new committee members this year. So ask away if there's something that you're not understanding or that you'd like to know. More than happy to have questions. Representative Lewis.
Yeah, just along those lines, I think it would be useful for, we've spoken about Brady and Giglio, just for a few minutes, tell us about those cases and how they set the constitutional parameters that, and then when they were decided, which is quite a while back, and then how that gets used in subsequent cases. Lower courts, both in the state and at the federal level, have to interpret that and explain then why there's never complete clarity because you're dealing with case law rather than statutes.
So
For non-legal.
for non-legal
Yes,
folks,
please.
I will
Okay.
explain this for non-legal folks. There was a United States Supreme Court opinion, Brady versus Maryland. And in that opinion, the United States Supreme Court said that defendants have a right to know exculpatory, or have a right to know what the prosecution knows in terms of what's favorable evidence. So the prosecution is required under due process to turn over evidence that is favorable to the defendant. The question becomes, what constitutes evidence that's favorable to the defendant? And that's where we get into this question of discretion. And certain times prosecutors will say this evidence is favorable and we have to turn it over, and other times prosecutors won't. And so when we're talking about jailhouse informants, the question is not just that we're using someone who has a criminal history, but do prosecutors have to turn over the number of times that this individual has tried to assist in other prosecutions? One of the concerns is whether or not they're telling the truth or whether or not they're actually trying to benefit themselves. And so there becomes suspicion when you're dealing with an individual who says, I can help 15 different prosecutors across the state in 15 different prosecutions. So at what point do prosecutors have to turn over their knowledge about that information? At what point do prosecutors have to turn over the individual's prior criminal history? At what point is there a bargain or favorable evidence? There are rules that require prosecutors tell defense attorneys if there is a benefit to that individual testifying. So if the individual is going to get their sentence reduced or charges dropped, they are required to tell the defense attorney that information. The question becomes, when does that agreement happen? And if it doesn't happen before trial or it's not formalized, then there is discretion about whether or not you have to turn that information over. The point of this bill is to take some of the discretion. Let me just back up for 1 second. The U.S. Supreme Court is not a court that adopts very specific rules that apply in very specific circumstances that tell you exactly what to do under all situations. The point of the U.S. Supreme Court is to provide these generalized guidelines about what constitutes due process, about what constitutes reasonable suspicion, about what constitutes probable cause. And they are left for the people or the prosecutors and the defense attorneys to then try and apply what is probable cause? What is a fair probability that a crime was committed? And that's where discretion comes in. And that happens also when we're dealing with individuals who are jailhouse informants, and that discretion is what we are trying to remove from the cases. So statutes are much clearer. They tell prosecutors and defense attorneys exactly what has to happen, at what point in time it has to happen, and exactly what information has to be given over. So it takes the discretion and the guesswork out of it.
And let's just be really clear that this bill would in no way limit prosecutors' ability to use these witnesses. There's nothing that says that it's not allowed or that you shouldn't do it. It simply says you need to disclose the information. Jean, can you remind us how long Brady and Giglio have been the law of the land?
Oh, Brady was decided in the 60s, so it's been around for a very long time. And although you would think, well, you know, that's, what's my math, 60 years ago or whatever, 60-something years ago, because it happened sometime in the 60s, if I'm correct. If you do a search for cases that involve Brady versus Maryland, you will find a slew of cases because there is constantly issues over what constitutes favorable evidence that has to be turned over. So it's just not clear. That's what we're trying to resolve.
Okay, thank you. Representative Lewis.
And just to explain then the Giglio case impeachment and how
Yes.
that's related but different.
Succinctly as possible.
Okay, I'm sorry. So Giglio allows for there to be impeachment. If there is evidence of which you can impeach the witness, you have to turn that impeachment evidence over, so that impeachment meaning you know something about them that might be able to impeach their credibility on the stand. And I'm thinking most clearly of prior criminal history. When you have crimes of dishonesty, you're allowed to impeach with that, because if they were dishonest in other types of crimes, they may be dishonest on the stand, and that information is required to be turned over to prosecutors as well, so that they have the ability to actually vet whether or not the testimony that's coming out is reliable. And again, the question is, what constitutes that evidence that has to be turned over to the defense attorney?
Thank you. Any other questions, committee? Okay, thank you.
Thank you.
Appreciate it. Yep. I'll now call up Floyd Bledsoe. Welcome back to committee. Nice to see you.
Thank you. It's a privilege to be here. My name's Floyd Bledsoe. I was exonerated in 2015, just about, 30 miles from here, 30 minutes, in a little bitty town called Oskaloosa, Jefferson County. And I served 16 years for a crime I did not do. I've had the privilege to testify before you guys on several different bills, and I am a product of what happens when somebody has discretion. In 2017, the legislative passed the Mandatory Recording Act, which required that all interviews be recorded because certain people decided it was their discretion whether or not to record my brother in his interviews, but chose to record me on every interview that I did. Fast forward, despite those same people testifying that Tom had never confessed, when we filed my civil case, we found evidence to prove from day one that Tom confessed in the police's own handwriting. I am here asking you and pleading with you guys once again to pass this bill and help refine and help to ensure justice is done for everybody. Not just for criminal defendants, but for the victims, so that they don't have to suffer twice. It should never be up to somebody's discretion of whether something is divulged or not. It should be law. Thank you.
Thank you, committee. Do you have any questions for Mr. Bledsoe? Okay, thank you for being here. We have now two proponents on WebEx. The first one, Olin Coons, are you there?
Yep. Can you hear me?
We can hear you, yes.
Okay.
Welcome to
Hi,
committee.
Thank you. My name is Olin Ben Coons. I am the son of Pete Coons, for whom this bill is named after. For those of you that are unfamiliar with my father, he was arrested in 2007 for a crime he didn't commit. He spent nearly 13 years in prison for that crime before he was exonerated. After he was exonerated, we had found that the key piece of evidence was a jailhouse informant that had been reaching out and seeking deals to multiple different prosecutors on multiple different cases. This information was never disclosed to our defense attorneys, so we had no way of knowing this. There was no clarity, there was no accountability during my father's case. As a result, my father was convicted and spent almost 13 years in prison. Now, finally, he was exonerated in 2020, in November of 2020. However, that freedom was very short-lived as he passed away in February of 2021 due to cancer that he was unable to have treated or even diagnosed while in prison due to his lack of freedoms. This case nearly destroyed my entire family. It is real people that are affected by these decisions. When accountability is not had, and when clarity is not provided, when prosecutors can't reliably do their job because they are given false information, because somebody is seeking a benefit, it corrupts the truth and justice of our system. The first thing as a witness when you take a stand is to swear to tell the truth, the whole truth, and nothing but the truth. And I know if my father was here, he would want to say that that was the case on anything going forward in the court of law. That is what our hope is here, is to ensure and include clarity, accountability, and truth in the court. And I hope by implementing these changes with House Bill 2131 that we can finally take a step in making that proper and right, so as that this sort of tragedy doesn't happen to other innocent people or their families. Thank you.
Okay, thank you. I think we'll go ahead and hear from Quinn, and then we'll see if the committee has any questions for you, Owen. Does that sound okay? Can you
Yes,
stay
that's fine.
on? Okay, that's great.
Yep.
Okay, then let's see if we can get Quinn on WebEx.
Can you hear me?
We sure can.
All right. Hi. Thank you. My name is Quinn Coons. I'm the youngest son of Pete Coons. As my brother said, in 2007, he was arrested and convicted of a crime he didn't commit and spent almost 13 years in prison. I was 7 at the time of his incarceration, and I was 20 when he came home. I spent my entire life dealing with this, and even after his unfortunate um, death, we still deal with it now. Um, my father was a big proponent on truth and justice and honesty. He believed that the court system would do right by him, and we hope that it can with the proper procedures in place. What happened to our family was a tragedy, but I believe that the most important thing you can do with tragedy is stop it from happening again. And I think that's our job to do now. And I truly believe that passing this bill will help do that, will help ensure that tragedies like this don't happen to more people. Um, my father hoped, and we hope we can carry on his legacy with this and bring about change. Thank you.
Okay, thank you, Quinn. Committee, do you have any questions for either Olin or for Quinn Coons? Anybody? Okay, thank you. Oh, I'm sorry. Representative Barth.
Thank you, Madam Chair. And thanks for the testimony. I have to say I'm one of those folks who is new to criminal justice. And so a lot of this is very technical. And so trying to clarify exactly what the bill does, the gap that it has, and understanding a little bit more detail and not knowing the history of this or any of the backstory is a little bit difficult. I feel like we kind of started a little backwards before we went forwards to some extent, getting the technical before we kind of got to hear the two sons speak, which, assuming that this has all happened, that's a really unfortunate situation. So sorry to guys hear that, but at the same time, I don't understand who was this informant that had this key piece information and why was it being withheld exactly? Like in simple terms, no legal jargon, just plain human speak as to what exactly happened. And because I keep hearing it's called the jailhouse witness testimony. So are we talking about a criminal that had information on another potential criminal? That's correct. Okay.
Okay, sorry. You need to introduce, and let me call on you and then introduce yourself. So go ahead, Mr. Scoggin. Yep. Mhm.
The jailhouse informant, these are people who are, yes, convicted of crimes, and they share a prison cell with a suspect or defendant. And in that time, so goes the testimony, the defendant or suspect will confess to their cellmate. That's the testimony that we are hoping will be clarified moving forward. Does that answer your question, Representative?
So in this case, the person that was in the jailhouse with Pete Coons was the person who actually committed the crime?
Not in this case. The crimes are completely unrelated to each other. So the jailhouse informant actually had convicted of nearly 30. It was 27 different crimes that jailhouse witness had been convicted of, and none of it had anything to do with Pete whatsoever. That person sends letters to different district attorneys across the state offering information, offering to be a jailhouse informant if hopefully they can get sentence reduced from their 27 different convictions.
Thank you.
Thank you, Representative. Thank you.
Ms. Phillips.
So I'm just going to add really quickly, because I know we're short on time. What happens is you put people together in the same cell and you have your documents. And the confidant or the jailhouse informant read documents of Pete. They find out what happens, they get information, and then they say to the prosecutor, oh, I know Pete confessed to me, and he didn't. It's because they've read the documents. It's because they're constantly pawing through that information because they want to help themselves, right? If they get on the stand and help convict somebody, they maybe do less time. And that's why we have that issue that happens and why defense attorneys want to know. so they can test the reliability of it.
Okay, thank you. Any other questions, committee? Okay, I will draw your attention to proponent written-only testimony, Clayton Perkins from our BIDS Legislative Committee. And then also Melody Bitzer, which you'll note in her testimony, she is the sister of Olin and Quinn Coons. So take a look at that. Any other proponent testimony? Okay, we will now call up the opponent testimony. First, I'll ask Megan Ossens to come up from the Attorney General's office. Welcome to committee, Megan.
Thank you, Madam Chair. Thank you, members of the committee. I was going to start off by talking about how being a prosecutor for 23 years has taught me that there are fewer differences between defense attorneys and prosecutors than one would think, or than the average person would be able to tell by watching crime TV shows or things like that. The representatives from the Innocence Project are 100% correct in the respect that nobody wants to send an innocent person to prison. Nobody wants that. No prosecutor goes to work every day and says, give me the most unreliable testimony possible from the squirreliest witness I can find, and you don't want to put that person on the stand. There's no incentive to do that. So I want to answer your question a little bit differently about what a jailhouse informant actually looks like from a perspective on the ground from my career. Prior to coming to the Attorney General's office and being the head of major crimes, I worked in the Johnson County DA's office. And I think you're going to hear from Steve Howe a little later today via WebEx. But I worked there for almost 16 years, and I've been a prosecutor for 23 years. I got into this because I wanted to help women and kids, victims of crimes, domestic violence, and sexual assault primarily. And I have seen jailhouse informant testimony before. It's happened in my cases. But it's a little bit different than they're sitting in the same cell together, and they have this nefarious person has access to a defendant's paperwork and documents, and they read it in order to get information for themselves. And I'll tell you why it doesn't work that way. Because when I get a jailhouse informant letter, and it's always via jail mail is how it started for me, there's a handwritten letter from an inmate, and I reach out to that person's defense attorney, and I say, your guy has sent me a letter, and do you want him to proffer? And if so, we'll set up an interview with detectives. No deals are made prior to the proffer happening, and no deals are made that the defense isn't immediately given access to and aware of. You turn all of that stuff over, including the statement that they gave to the detective when they proffer. But the detectives do more than that. They actually look at this information and make sure it's verifiable. Did this person have access to this person's paperwork in your cell is a big question. And if the answer to that question is yes, I'm not going to use that witness, because it's easy for the defense attorney then to pick apart that testimony, and it makes me look silly in front of a jury. And also, I can't be sure that that person is telling me the truth. I would never put somebody on the stand who I think might not be telling the truth in this case, especially because, well, we use live ammo in my job, okay? We are dealing with people's lives, and we take that responsibility incredibly seriously. Now, to the respect of my written testimony, I would point you to it. The big thing that I think I want to say in addition to what I have written down is that it's horrible what happened to Pete Coons. I don't think anybody would say any differently. I don't know a single prosecutor who would think that this was a good outcome. This is terrible and not what we want. The prosecutor in that case acted unethically and did wrong things. That prosecutor would not have done anything differently, probably, even given this bill. Even if this bill was passed, there is no evidence that this would prevent the harm that they're trying to prevent. Because, and the additional rules, or these aren't even additional rules, these are rules that are actually already in place. So it's redundant in a lot of respects, and I cited all the specific examples in my written testimony. These rules are already in effect. These rules are already required. Turning over witness statements is required. Turning over criminal histories is required. Turning over impeachment evidence is required to do that. We're already required to do all of those things that this statute says. It doesn't clarify anything. And none of what is written in this bill would prevent what happened to Pete Coons, because that prosecutor wasn't following rules that already existed anyway. So there's no reason to suspect that that prosecutor, who clearly did wrong things, would follow what was in here. One thing that was missing from the Project Innocence folks, and I'm sorry, I've forgotten your names, from their testimony, they mentioned a lot about Brady and Giglio, and that's true. Those are constitutional obligations, and sometimes those can seem a little vague, yes. But what isn't vague is what I cited in my response, or in my brief, which is KSA 223201, which is the discovery statutes. We have 2 discovery statutes in criminal law in Kansas, and they require us to turn over every single piece of evidence that we are going to use against a criminal defendant. There is nothing that is a surprise for a criminal defendant in Kansas. We turn over everything. There's an open file policy at every DA's office that I'm aware of. We get a piece of discovery, a new police report, it goes out to the defense immediately. We have a jailhouse witness. More often than not, I've not used my jailhouse witnesses, to be honest with you, because we have a PIC instruction in Kansas, which I also cited to, which tells the jury, view this testimony with caution, jurors, because this person's getting a benefit from this. So we go one step further in Kansas and actually tell juries in the jury instructions that they should view the testimony of jailhouse witnesses with caution. That's already something that we're telling jurors. So usually it's not worth it to use their testimony. It would only have to be in a situation where the information that they gave us is incredibly reliable and verified by other forms of evidence. It's not just, we're going to go to trial on this one piece of evidence, this one person's testimony. That is never what happens. It is always additional evidence that occurs. If wrongful convictions have happened, and they are a tragedy, but the bigger tragedy in this bill is the database requirement. I think that that's the part that we really have a problem with, the prosecutors really have a problem with, because, and this wasn't addressed at all, we were blanketly assured by Project Innocence that the safety of these witnesses would be assured. How is my question to them? How is that assured? This can be hacked easily. And there are people who would pay good money for snitch information. This bill would quite literally, and everyone's heard the vernacular or the phrase, and please excuse me for using the vernacular, but this bill would quite literally give stitches to snitches. These people's lives could be in danger. And the existence alone of a central database that could be hacked is going to chill people coming forward. The jailhouse informants that I've used in my cases are people who came forward, some of whom didn't even ask for a deal. In fact, I would say about half of them don't even ask for a deal because they're already going for something else, but the defendant told them something so horrible that they had to come forward in good conscience. I've had people come forward after they were out of prison and they don't get any benefit from me. There's nothing I can do for them. But they came forward to say, hey, look, I went to prison for drugs or whatever, but this guy's talking about killing a kid. And that's across a line that this person won't tolerate. And they come forward and cooperate. Something like a centralized registry like this is going to chill people like that from wanting to come forward. And I'll just leave you with the same notion that Project Innocence did. Clarity is important. I agree. Clarity and truth in our convictions are incredibly important things. Preventing people from coming forward with evidence that is usable, valuable, and truthful and verifiable in criminal cases is not something we should be in the business of doing. We should be in the business of encouraging people to come forward. I'll open myself up for questions.
Okay, thank you. If you can stay, I think we'll do the 2 other in-person opponents and then let the committee ask questions of all 3 of you. So
Thank you, Madam Chair. Thank you.
Okay, Michael Kagi from the Shawnee County DA's office. Welcome to committee.
Thank you, Madam Chair, ladies and gentlemen of the committee. Thank you for your time. The previous speaker did a really nice job of covering a lot of ground, so I'm going to focus my comments on a couple different areas that have not been touched on yet. So the language of the bill was made available, I think, last night for the first time to my eyes. And so I took a look at it, I reviewed it. I wasn't part of the conversations on any prior version of the bill, so I can't speak to that, the procedural history, what have you. But I am an attorney, so I went through the bill piece by piece, and something caught my eye. In particular, where it says the jailhouse witnesses cooperation agreement, any benefit that has been requested by the jailhouse witness.
Okay, real quick, make sure you speak up.
Okay.
Because you're kind of far away from the microphone.
Okay, yes, is this better?
Yeah, that seems better. And then, do you know in the bill where it is that you're addressing?
Yes,
Like
I'm
what
looking
page
at,
and what line maybe?
I'm looking at the first page under B.
Okay, thank you.
So, very first page, where it says the jailhouse witnesses cooperation agreement and any benefit that has been requested by, that's where I'm talking about.
Okay.
And so, you know, we've heard about other states that have adopted pieces of this legislation. We've heard about the model legislation that's been approved. And I'll ask the proponents to correct me if I'm wrong, but I have looked at different states. I have looked at their laws. I have failed to find a single state that has this same provision in it. And I'll explain why that's important. Not unlike the prior speaker, I am contacted on a regular basis by someone who's incarcerated, and they have a letter, and they purport to have information. Most of that information, in my opinion, is not credible, primarily because discovery has already gone out. So the paperwork is present in that facility, and we just have to assume that they've seen it, they have access to it, and so we're not going to give that any credence. And so we will also contact their counsel and advise them of the same. Every once in a while, we do get something, either on an uncharged case, so there is no discovery, there is no paper trail, but the person is in custody, and they'll send a letter that says something like this: Mike, I have evidence on an unsolved homicide from 2 years ago. Here are the people who were there. And then they'll give some other specifics that make you think they tend to know something, right? If we are going to request, or we're going to require every single prosecutor in this state to collect and document anytime a request for a benefit is made, right? I'm not talking about a promise of a benefit. That's different. So I know we have some lawyers in the room. There is a big difference between someone asking me for a favor, right? Or better yet, asking a government agent for a favor, and that favor may not even be passed on to me, so I may not even know about it, versus I know what's going on and I am offering you something in exchange for your testimony. And what I'm concerned about here is that we're going to get into a situation where someone is not using a jailhouse witness at all. The prosecutor does not know that there's a jailhouse witness anywhere. They don't need them. They're not using them. They move forward in their case. They obtain a conviction. And then in a post-conviction setting, someone comes forward and says, well, I did say something to somebody, and I asked for a benefit. Under this language, right, we're now looking at a real problem on appeal. And this is going to lead to unnecessary litigation, and I think this is probably why that language is not present in any other state statute in this country. And again, I'm happy to be corrected if I'm wrong. The Coons case, and I don't know all the specifics, certainly, but it's an unspeakable tragedy. Prosecutors have an obligation to pursue justice and pursue the guilty, as well as protecting the innocent. And clearly, the prosecutor handling that case failed to do so. But that's about prosecutorial misconduct, right? So we have laws in place. For example, we have laws that regulate how you can drive on the highway. And people that want to speed are going to speed, regardless of what the law says, right? So it doesn't necessarily preclude the harm from occurring, doesn't stop it from happening. And I think there are some points in this bill, like the one I mentioned, that are kind of missing the mark. There are ways, there are procedural protections that you could put in place, and that have been adopted in other states. The bill as written is largely redundant and does not achieve the goal that the proponents purport to, what they're trying to achieve here. I don't think it does the job. In looking at other statutes, I also came across an Oklahoma statute that talks about some of these same elements. And it does have some requirements around the use of jailhouse witnesses. But it also has a section entirely devoted to defense discovery obligations. And I'm reading this and I'm thinking, what is this? Because in the state of Kansas, the prosecutors, as the prior speaker told you, the prosecutors have an obligation to hand over everything we have. Whatever we're going to put on, whatever we're presenting, we have to hand it over. And we have a deadline to do that. And defense has the opportunity to review it and poke holes at it and attack it. And that's great because we carry the burden. That's the way it's supposed to be. But apparently in some other states, not in Kansas, defense has that same obligation. So just because it's happening in another state does not mean it's in line with longstanding values and practices in our own. Thank you for your time today, and I'll be happy to answer any questions at the
Hey,
appropriate time.
thank you. We appreciate it. You'll just wait. We'll go ahead and ask Mark Bennett to come up, our DA from Sedgwick County. Thank you for coming up.
Very much. Like my two previous prosecutors, I'll share their opinion. I largely agree with much of what the Innocence Project folks have had to say, with one couple of points of clarity here, or points of distinction. This isn't a matter of clarity. This is a matter of character. This bill, if written, if passed, would have done nothing to stop what happened in the case in Wyandotte County. The prosecutor knew certain things, and apparently this individual, this witness, was trying to share his, or trying to sell his testimony to anybody who would listen, and he got one taker. One taker who refused to share that with the defense in this case. You know, that is prosecutorial misconduct. That is arguably criminal. But adding or saying that he had a way out because it wasn't particularly clear in Brady or Giglio or in these other cases, I fundamentally disagree with that. There's no lack of clarity on what my obligations are. Just to get back to the sort of more of a rudimentary level here, how does this manifest itself on a day-to-day basis? I get calls from people say, hey, I got a client in the jail, says he knows something. All right, I don't talk to him. I'm not gonna make myself or any member of my staff a witness. I send the detective over and say, if your guy wants to talk, he can give a statement. As soon as the statement's done, we transcribe it. I give all of it to the defense. I use it 1 in a million times, almost never. I've tried 160 jury trials myself. I've used 2 jailhouse snitches. One of them was that guy who was in a gang with the other guy, and he knew him already. They ran together for years. Told us that, he goes, if he didn't know it, the gun he used in this murder, he used in another one 2 years ago. We checked. Sure enough, it's the same gun. By the way, I tried that case with the other murder he'd already done. Jury convicted him on the one we knew he'd done. The one that jailhouse snitch testified on, jury flushed it because juries don't like these guys. So we never, twice in 160 jury trials in 30 years have I used these guys because they're lousy witnesses. But if they come forward, I turn it over. I guess I'll point out a couple of other things. The reality is this is a tragic situation. And there may be an incentive here to say, look, his family came forward, this guy suffered enough, we need to do something to try to right the ship. And if you want to pass this, okay. But if you're really going to do so, there's a couple of points I would make about this bill and why this bill, first of all, I don't think would have changed anything in this case. But hope springs eternal. But if we were going to do this, I share Mike's concerns, first of all, with the intent to induce testimony from section 1, line 11. And then the other comments he made about asking for some sort of help. If you're going to say that prosecutors are responsible for knowing every time somebody in a hallway says, hey, I got a guy that might know something, and that goes into a database, we might as well just bake in error to every case we try, because those kind of conversations happen a lot. And maybe that sounds a little hyperbolic. I don't mean it to, but it happens a ton. Someone who receives a benefit, who testifies for benefit, no problem. And frankly, if you wanted to use subsections A1, large A, B, C, D, E, and E, and just put them into the discovery statute so that this clarity that, again, I'm not taking issue with what Gene said. We sat in the same room together on the crime reform committee, and we worked together to try to make the criminal justice system better and safer in Kansas. So I get her point, but if you wanted to do that and add clarity, then put it into the discovery statute in chapter 22, and it's there with that clarity. A couple of the points I would make. The the Cora, the thing about the chapter, about sunsetting in 2029, I gather there is an acknowledgement and a friendly amendment that would say there is no sunset provision, that it would never be subject to Cora is something they're okay with. If you're going to pass this, I share the concerns from my contemporary in the AG's office. The risk to folks on this list would be profound, and you would need to ensure that it was never sunset and no one ever let this be subject to open records. I would point out, I know this is maybe hyper-technical, but I think that the very definition of a jailhouse witness is problematic. This could include crimes that occur in the jail. Just a few months ago, we had a jailer who was attacking a female witness or female inmate sexually in the jail. She didn't tell anybody, but she told another inmate, another female inmate, this guy's doing this to me. That inmate told her lawyer who came forward, we charged the guy. I know this is not what's intended, but by the very definitions here, one inmate telling another inmate makes that person a jailhouse witness. I don't think that's what you're intending to do here. Trying to get these guys, the one that's been described here, this Rupert character, who is essentially trying to become a professional witness for prosecution. That is not this. I'm not saying that that's a bar to this, but you'd need to correct that in this statute. And frankly, I think what they're trying maybe threw in there to try to fix or try to encompass that was this notion of a third page, top line, confidential informant. There's no definition of that. That means different things to different people. I think you'd need to flesh that out. And if you're really moving forward with this, you're going to need to, I would really suggest you identify what a confidential informant is specifically, because that could mean a lot of things. So fundamentally, why did I drive up from Wichita on this day of all days? It's this. I do the things that are in this bill. I turn over this stuff. My office is too big. I have too many cases to pick and choose. I pointed out, not that but over almost 6,000 times a year we turn over discovery, terabytes of information over and over again. I don't have the time to navel gaze about what is or is not exculpatory. We get mountains of evidence. We simply copy it, turn it over, and give it to the defense. The only reason we copy it and do that is so we can ensure that we gave it to them. So a year later in a trial, someone says, I didn't have this page. I can go, yeah, you did. We gave it to you last March. And that's why we handle it that way. My concern is that this database now makes it the responsibility of the state. We have 105 counties. I don't need to tell you how the shortage we have of attorneys right now. We've had at least 2 or 3 counties that did not have a prosecutor running for office this last November. Half these people that are in prosecutors' offices around the state are there for a short period of time. They're part-time prosecutors, and they're gone and doing something else. Harper County had 6 in 18 months. And if one of those guys didn't turn something into the database that's proposed, and then that witness comes over, and by the definition here, if you were ever a jailhouse witness, you are a jailhouse witness. By this definition, if they come and testify later simply as a witness, as a victim, but they were a jailhouse witness in the past, I would have to disclose that thing. And if I didn't know about it because another jurisdiction didn't put it in the database, I'm on the hook for it. And that speaks to what Mike said a moment ago, leading to more litigation. So again, I have concerns about this jailhouse witness. If you're talking about someone who was a jailhouse witness once, is about to be a jailhouse witness again, then absolutely turn over anything that can be known. And I said one final thing in my written testimony. I'll stand on that. But I said one final thing in my written testimony, and I didn't mean to be not cynical here or being funny about this. If you truly want to ensure that defense attorneys have more information and have the most information at their disposal across the state, 84% of cases, I get this from Heather Cessna's testimony before this body last December, or before I can't remember which committee it was from, but she testified, had written testimony in December of 24 about what goes on and why she needs more funding. One of her points was 84% of all criminal cases in the state are defended by public defenders or people who are private lawyers paid for by BIDS, Board of Indigent Defense Services. Rather than spending 180 grand, I think that's the fiscal note on this, plus an FTE. I don't know what the FTE will be, but 80, 100,000, $250,000 a year, annually, forever. Rather than doing that, and I know Heather may take issue with me speaking for her, and I don't presume to, but if I were you, I'd rather spend the money on a new records management system for BIDS. And then they can all share the information across the state among themselves. as long as they want to. I have no problem sharing information. I have no problem with even having if the defense attorneys want to put it all into a repository. But when I'm now responsible for what another prosecutor might do in another county around the state, I have no control over someone who might do that job for 6 months, a year, or someone who might, like the guy in Wyandotte County, essentially ignore the rules that are very clear. And that could affect my case. That is why I drove up from Wichita today. I have no concern with sharing information. It should have been shared. This case should have never happened. And if the guy had done what he was supposed to do, what he was sworn to do when he swore to uphold the Constitution, this never would have happened. But again, this is not a lack of clarity. There is no lack of clarity in our law. This was a lack of character on the part of the person who committed prosecutorial misconduct. So that's my 2 cents.
Thank you so much. Committee, what questions do you have for the last 3 opponent testimony? Representative Lewis first.
Yeah.
You can just ask whoever you want to come on up.
Mr. Bennett, please. Thank you for coming all the way, and we really do appreciate your input here. You mentioned knowledge. You're obviously can't give information you don't know, right? So my concern, and maybe you share it, maybe you don't, is that this jailhouse snitch that reaches out to you has also reached out to somebody in Garden City and Goodland and all over the state. And currently, you don't know that, right? Because there's no database to tell you that. But you would agree, would you not, that that would nonetheless, if known to the defendant, be material that they would quite likely use to cross-examine your witness?
Turn that off. Sorry. Thank you. Yes, I agree with that. I
Just
wish I would
introduce
know that.
yourself. Sorry, for the people
Oh,
online.
sure. Mark Bennett,
Thank you.
District Attorney, Sedgwick
Thank you.
County. I agree with you that I wish I would know that, and I wish there was a way to do that. My concern is that if it doesn't get shared with me, and then the state has an obligation to put that in there, then the state writ large did not provide the information, whether it was my fault or not. And so, yes, I am in agreement with you. I don't disagree with their motives. I don't agree with your premise or disagree with your premise. I just am concerned about a responsibility that I share information that I don't know about, and I don't know that I've ever actually gotten. And if I don't turn it in, and they should have turned it in Garden City or wherever, that could be held against me in my case. Because the Giglio case, just so you're clear, the prosecutor in Giglio tried Mr. Giglio for his crime. What he didn't know is that one of his own another assistant U.S. attorney had made a deal with the witness. Number A never told Prosecutor B what was going on. Prosecutor B innocently went in and tried his case thinking he had done everything he could do, not knowing this deal had been made. And that overturned the case, of course. And that's what I'm trying to work on. On a very technical point of view, I'm not sure that you could cross-examine somebody with that thing anyway in Kansas. That's hardly the point. But yes, I agree with everything you're saying. My concern is how to do it without me being responsible for someone else's, another prosecutor in another part of the state, entering that information adequately.
Right. I have other questions, but not for this.
Go ahead with one more, and then if we have time, we'll come back to you if you have more after that. I have several people on the list.
I'll ask Mr. Is it Kage? Am I getting that right? Yeah. Okay.
Mike Kage, Shawnee County District Attorney.
Would you agree with me that if a jailhouse lawyer, I'm sorry, a jailhouse witness, there are jailhouse lawyers too.
There are several jailhouse lawyers as well. Subject for another bill, maybe.
Had reached out to 10 different prosecutors in the state asking for benefits and telling them they had testimony on a variety, 10 different defendants, that is something that would be exculpatory or giggler material if known to the prosecutor.
Well, sir, I think your question presumes that they did not in fact have that evidence.
It does. Yeah, well,
Assuming they did not have that evidence and they were doing that, then certainly it's something that you would want to know and share. I would point out in the Coons case, the prosecutor who committed misconduct did contact a prosecutor who was more familiar with the witness in question and was advised by him that he was not reliable. And that was his reputation, and he proceeded in spite of that. So again, as Mr. Bennett said, this is not about clarity. This is a failure of character.
okay, I'll stop there.
We'll try to come back. Representative Schreiber.
Thank you, Madam Chair. And this would be for Ms. Austin. Since the word,
It's Attorney General's office. Thank you.
and I'll use a word that's been used a lot in the testimony is clarity. Your comment about the database was one of your chief concerns because of the security of the database and the impact it might have on safety of the jailhouse witnesses. Is that, did I understand that correctly?
Yes, those are my two primary concerns. I also share a concern of having one of my cases flipped because a prosecutor somewhere else who did not, or for whatever reason, didn't know their obligations or didn't turn it over to this database, that my case could get flipped because of that, which results in real damage to victims and their families because they have to be re-traumatized over and over again every time we have to retry a case. So we try to do everything we can to make sure an integrity of a conviction stands. But my primary concern is for the safety of these witnesses.
So my question is on security, since I'm sure there's some standard of cybersecurity that's applied to this kind of thing. How would that be less secure than the paper that you're receiving? The letters through the jail mail, that kind of information. Wouldn't that also be liable to be disclosed some inappropriately?
Well, sure. Well, we turn all that stuff over to the defense as it is. So whenever I get those letters that you're talking about, whether or not I use the testimony, I talk to that person's lawyer because they usually have a lawyer too. So I'm not going to talk to somebody who's represented. And then I will also disclose that in the discovery on the case that this person wants to talk about, whichever it is. I'm inmate A, I want to talk about inmate B. He told me X, Y, and Z happened. I'm going to turn it over in that case as well. So both parties are going to be made aware of that. But as far as somebody being able to hack an internal database for the DA's office, I haven't seen that happen before, to have police reports, because that's where this information would go. It would be in a police report of some kind. And then I've never seen that happen. I suppose that it's possible, but a central database of all of them. If I am a gang member or I am a family member who's very angry at somebody for testifying against my loved one, or a gang member who is mad because you testified against a fellow gang member, or a member of the cartel, this has come up, a member of the cartel who's upset that this other member of a cartel also testified against them. If I can find one central place to get all of that information, that's going to be incredibly valuable. So their ability to know that in one random case in Johnson County, this person sent the letter to a prosecutor, their ability to know that would be very limited. Their ability to know that a statewide database exists, on the other hand, they're going to find out about it. It's going to get out, and there's a huge incentive to hack that.
Okay. Thank you for the clarity. Thank you, Madam Chair.
Representative Vaughn.
Thank you, Madam Chair. This question could also be for Ms. Ossens. Is that correct? Okay.
Very good. Yes.
So I understand, the differences on things like the tracking system between the proponent and opponent testimony. The one thing I'm still trying to reconcile is whether or not there is clarity in the law. So we hear from the proponents that, there is discretion in terms of how benefit is defined and the timelines during which that discovery has to be turned over. And in your testimony, you talk about how under Kansas law, all discovery must be turned over. It sounds like that's exculpatory evidence, not, or is it all evidence in general? Okay.
It's all evidence, yes.
So is there still a situation in which a prosecutor and defense counsel may disagree what qualifies as a benefit under the law in terms of what that discovery is? And I'm not an attorney, so I'm asking this to the best of my ability, but.
Sure, fair enough. I wouldn't say there'd be much disagreement about a benefit because the benefit is usually a plea agreement. That's usually what they're talking about, is a plea agreement of some kind for this inmate in order to testify truthfully against this other inmate. We listened to your evidence that you provided. We backed it up by doing our own investigation. It's credible, reliable. We're going to use you. But again, as they said, that happens so incredibly rarely. But no, I would not say there's a real meaningful difference on what a benefit is, because that's what we're talking about. I don't know what happened in the Coons case. I'm not sure what a handshake benefit even means or is, but if there's any kind of an agreement between you and somebody to testify and you're giving them something in exchange for that, you must turn that over. There's no disagreement with respect to that. And the discovery statute lays out everything that we have to provide, which is all evidence that we're going to use in the case. And we turn over all evidence whether we use it or not. All the police reports get turned over. Everything that's given to us, just like Mr. Bennett said, it's literally copied and given over to the defense. Everything in the case. There's nothing that is a mystery in that situation. So I do not agree with them that the existing laws lack clarity. They failed to cite to the discovery statute, which requires us to turn all of this stuff over, not just stuff that's potentially exculpatory, but all of it. We turn over everything. And if they have a problem or think they're not getting something from us, that happens. And they'll file a discovery motion with the court, and then we go to court and they argue their side and say the state should have to give us this. And we'll say, we don't have that, or it's usually we don't have that, and them wanting us to get it for them. And they have a mechanism whereby they can get evidence too. They have investigators they can use. They have subpoena power as well. They have the ability to get evidence for themselves, and the court will usually require that if that evidence is not in the custody or control of the state or can't be reasonably gotten by us. If it's something easy that I can get for them, I will. But if it's something that I don't have and they're going on a fishing expedition and they want mental health records of a child victim, for example, I'm not going to provide those because I don't have those. So that's going to be up to a judge to order that. So those disputes are worked out in court way prior to trial.
Thank you. That helps. And then I think the other thing they brought up was discretion and the amount of time that it takes to turn that information over. Do you agree that there's discretion there? What's standard practice?
The statute requires that you turn over everything to do with defendant's statements prior to a preliminary hearing. So felonies have a preliminary hearing, and then the next stage is usually motions or a jury trial after that. But a preliminary hearing, you have to turn over only what the defendant has said. So everything that, if you had a jailhouse witness, for example, and a defendant spoke to that jailhouse witness, you'd have to turn that evidence over because that's a statement by the defendant. You have no choice. That's in the discovery statute. But most offices that I'm aware of turn over the entire file well before the preliminary hearing. That is standard practice from what I'm used to. I'm not saying it's everywhere, but before the trial, and I think the deadline is usually 30 days before the trial, but that's usually worked out in a pretrial discovery order, you have to turn over every single thing you have. But there are requirements on this, and it almost always goes out in the beginning of the case before there's ever any meaningful hearings anyway. So the cases that I have personally worked on, all the discovery has been given over before. And if we continue to get discovery, we continue to turn it over. So if something comes in late, they're going to get it late, but that's because we got it late. So they get everything we get.
That's helpful. Thank you.
Mm-hmm. Committee, are there other questions? Oh, no, it's fine. Representative Barrett first.
Thank you. My question is for the Attorney General's office as well. So one point you'd brought up that I hadn't thought about is the security of the database. So 2 years ago, and first let me preface this with a lot of the crimes that are charged, especially in our bigger districts, can include your trafficking crimes, gang crimes, so some pretty serious crimes that can have national, international connections, correct?
Yes.
So with this database, can you give me an example of a security breach of a statewide software in Kansas within the last, I don't know, year or two that's happened where foreign entities hacked a system?
Yes, I think that they're pretty well known that there have been some hacking issues with the state of Kansas. I think even most recently, I think all of the attorney data that we have for the bar, I believe every attorney in this room got our data hacked. and released. I'm getting some nods from the lawyers on the panel. So that would be one example of a statewide database that contains a lot of information about us, and it was all hacked recently. And I believe there's been other issues as well.
Thank you. And I'll just add also our Kansas court system was hacked. Thank you.
Yes, that too, for sure.
Representative Bohai.
Thank you, Madam Chair. Yes, just really quickly, one of the, I believe one of the items you may have issue with this bill was that this would then, if there was this database, it would make people would be less likely to come forward. Since this has happened in other states, have you been in communication with any other Attorney General's offices where we are having this issue that people are no longer coming forward in this regard?
I have not.
Thank you.
Committee, any other questions? Representative Barth.
All right, I think I'm a little bit more caught up now on everything, so thanks, Madam Chairman. This database, would it contain information on someone who's purely an innocent bystander that has witness information in addition to not just a jailhouse witness that would information would go into this database, or would it be all kinds of information?
No, it appears to be, although I do agree that the definition of jailhouse information or jailhouse witness is overly broad and could capture inmate on inmate violence where someone's a victim of a crime in the jail, and that would also be included in this. So they would also be labeled as a snitch, for lack of a better term, for just having been a victim of another inmate's violence inside the jail. So yes is the answer to your question. It could actually have a bystander effect, but generally speaking, I do not believe that is the intent of this. This is for people who are being used as jailhouse informants. I also don't think it's clear from the language of this bill, and I'm happy to be corrected. It's not clear from the language of this bill if somebody just reaches out, and this is an answer to your question, sir. If somebody just reaches out to a prosecutor, but no action is taken, the person's never used, they didn't do an interview with them, no investigation was done about their information, the letter was just given to the defense attorney or shredded and never used or looked at or talked about, does that create this obligation to report this person even though you never used them as a jailhouse informant? They never took the stand for you, you never testified, none of their information was vetted. Because if that's the case, then that's putting a huge burden. We get these letters a lot. Having to report to the KBI every time you get a letter from somebody like this would put a crazy amount of burden on prosecutors' offices that are far less capable of handling because of the size, because of a lack of resources, because there's not a prosecutor sitting in the office all the time. That would create a massive onus on prosecutors across the state, and I think an unfair one and an unnecessary one. I went way beyond the answer to your question. I'm sorry about that.
Committee, I'll go to Representative Lewis if there's no other questions. That'll be the last question. Go ahead.
I'm fine.
You're okay? Okay, any other questions? I do have one question, and I know we have a representative from the KBI here, and I'm just curious about your thoughts about a data breach in a database that the KBI had. If you would introduce yourself. Thank you for coming forward.
You're welcome, Madam Chair. My name is Tony Mativi. I'm the director of the Kansas Bureau of Investigation. We have thus far been pretty successful in protecting our information from outside breach. Our systems are attacked. There are attempts to attack our system. We are the criminal justice repository for the state of Kansas. That is a part of our mission. We strive to maintain the security of that data. There are attempts to hack our system literally thousands of times a day. None have yet been successful, but that's something that I worry about every single day, is the security of that data. When I took this job, my predecessor had resisted any attempt to navigate or to navigate to the cloud, because any data that you put on the cloud is inherently at greater risk. We saw the magnitude of that risk with the OJA breach that was mentioned earlier. If that sort of breach happened at the KBI with regard to the criminal justice information that we have, it would be catastrophic. That said, with all due respect, Madam Chair, the Legislative Budget Committee and the governor stripped out of our budget this year about $1.2 million in enhancement requests that we had for the purpose of IT security. So we have been successful. We try very hard to be successful when it comes to protecting that data. but it's difficult when it comes to requesting resources, because that's often the first thing that gets stripped out of our budget is requests for those kinds of enhancements. And we've had that already this year.
Okay, I really appreciate you addressing that. Thank you.
Thank you, Madam Chair.
Yep. Committee, I will draw your attention to also other opponent testimony. We do have Steve Howe from the Johnson County DA's office, does have his hand raised, and I think he would like to go ahead and give his testimony. Is he there?
Can you hear me, Madam Chair?
We sure can. Thank you. Welcome to committee.
I won't duplicate what has already been said, but since my county sits on a state line, one of my concerns is our duties and responsibilities to provide information related to other deals that were made. I'm just envisioning, we have a lot of criminal conduct that the same individuals are in Jackson County as well as here in Johnson County and Wyandotte County. I would be responsible for things that happen in Jackson County or other parts of Missouri or other parts of the country based on the wording of the law as constructed now. And I have no ability to get that information, nor do the prosecutors in those states have any duty to turn that over to me. And so my concern is being held responsible for something that I can't legally obtain or force someone to obtain or give to me. And that's my concern. Miss Bledsoe indicated, Miss Phillips indicated that she wanted clarity, and I agree with Mark Bennett. Unfortunately, this bill doesn't provide clarity. It actually provides some lack of clarity because it causes duplication, as indicated before. And plus, it uses terms that now have to be defined through case law that has already been firmly established, such as in Section 2, due diligence. What does that mean? In Section 3, likely to cause bodily harm. And from a lawyer standpoint, when you start using these terms, you literally start to create legal arguments that have to be vetted out across the state through our appellate courts before we know what we're responsible for. The other part of Section 3 that concerns me is it says that we don't have to provide if we think there's a likely cause of bodily harm to the informant. Only the attorney would be provided that information and not their client. I don't know how that passed muster because it's the defendant that has the obligation to have discovery turned over to them. And if the attorney is looking at it but doesn't provide it to the defendant, basically what we're creating or setting ourselves up for an appeal, and also what we call a 1507, which is that the attorney didn't represent me, represent my rights to the fullest degree required by law, and then overturning the conviction. And so I have a real concern that this creates a real ethical dilemma for the defense attorney, as well as creating additional litigation. You know, I don't want to belabor the point, but what I will say that what happened in this case offends good prosecutors across the state. Mr. Coombs, we need to be upfront and honest. This morning, all of my prosecutors took an oath of office, and that is to uphold this Constitution of the state of Kansas and the United States Constitution. And we take that very seriously. And my chief deputy and I talk about all the time that we're ministers of justice. And I'm as offended as much as the Innocence Project by prosecutors who don't follow our ethical duties. And in this case, nothing that this law has constructed would change the scenario involving Mr. Coombs. And that's unfortunate. But what we can do is continue to work hard to train and make sure that prosecutors are doing their ethical duties, which is do the right thing. And so I'm asking that if we do consider passing this bill, that the Innocence Project take the opportunity to sit down with some of us prosecutors and craft a bill that doesn't create complications instead of clarity. And so that is my request, and thank you for the time and the opportunity to speak to all of you.
Thank you. We appreciate that. Thank you for waiting. I know you're kind of really towards the end of the meeting, so I appreciate that. We might have a question, but I'm going to go ahead and call on Susan Richmeyer, the Finney County attorney, if she's still on WebEx.
I am still here. Thank you.
Hey, we're still here too. So
I see
please
that.
go ahead. Welcome to committee.
Yes, thank you for the opportunity for allowing all of us to give you our positions on this bill. And I will join everyone and say that this was a tragedy that happened. And I think in large part, it is one of character and one that we as prosecutors really beat into the heads of our attorneys that are underneath us and even our law enforcement, that we need to turn over every single thing that you have, and we do. I don't really have a lot to add to what's already been said, but coming from a more rural area and seeing the lack of resources that our prosecutors have in these smaller communities, I'm like everyone else that's testified today. We get calls all the time. Do we do this? Do we do that? What's right? And our answer is everything. You send everything. It's not a question. You let everything go. If you have a question, my answer and my response is always, if you're asking me the question, you know you need to turn it over. There's not another answer to that. But these smaller communities don't even have even a central case management system. A lot of them are using their own Word folders and their own documents, and they don't have a centralized database themselves. And that becomes problematic when we start to talk about how do we develop any sort of record management system for a database that can be shared across the state. And I would even argue that our own courts and prosecutors in general, we don't have the software that talks to each other as it is. And so that just presents another problem and another thing that adds to the lack of clarity that we're talking about here. And I think it's important to remember too that the law in and of itself is not black and white. It's not. That's why we have appellate issues all the time. That's why we are constantly trying to flesh out what does this word mean? What does that mean? And as we create additional laws and we create additional expectations that go with that, along with it comes the other side, and that is, what's the definition of this? How does that play out long term? And in this case, are we creating more problems than solutions with the way this is worded? I would join with everyone. I don't think any of our prosecutors across the state fundamentally disagree with what is in this bill. It's how does it play out in real life? And a lot of it is already there. We have it in our discovery statutes. Maybe there's sections of this that could be added to our discovery statute to make that more clear. But I do think we're all interested in doing what's right. We're all interested in having successful prosecutions that aren't challenged on the basis of someone who's not telling the truth. And I would just close with, if we need to come together, I know we're all willing to come together to come up with language, insert it where it needs to, that will work and it plays out as it should and not creates additional problems. So that would be I think our position with regards to moving forward is, if this is something that everyone feels is necessary, then let's sit down together and figure out a way to move forward with that clarity that's not quite here yet.
Okay, thank you. Thank you so much. In committee, do you have any questions for Mr. Howe or Ms. Richmeyer? Anybody? Okay, thank you both for appearing. I'm sorry, Representative Lewis.
Yeah, I just wanted to thank my Finney County prosecutor for coming and talking to us. It's Bob Lewis. Hello.
Thank you, Bob.
Great. Nice to see a familiar face. Okay, so if there are no other questions, committee, I will just draw your attention to other opponent written testimony. Ed Klump, whom you know, and Todd Thompson from the Leavenworth County Attorney's Office. Thank you, everybody, for staying. We appreciate all the opponents and proponents. Appreciate you being here. Wait until the very end. I'll now close the hearing on House Bill 2131. And committee, we are not having a meeting tomorrow, but the agenda for next week will be kind of ongoing. We're really, one benefit of having session last 2.5 hours is that I did get 3 extra bills today because of the that we've been waiting on. So we'll get those scheduled. So the agenda next week will be changing. Take a look at that. And thank you all so much and have a good weekend, everybody. And wait, one last thing. Oh, everyone, don't forget. So Monday is the last day to request bill introductions. So Monday is the last day that I'll be having that on the agenda. Okay, thank you, everyone. Good night.